Good afternoon.
All right, we ready to go out there?
Yes, Your Honor.
All right, this is cause number CR 19-318, State versus James Laneir. And this is going to be a plea today, Mr. Harden, is that correct?
Yes, Your Honor. The district attorney and I have reached an agreement that my client will do 8 years and whatever else he says on it.
All right, Mr. Laneir, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Your name is James Laneir, is that correct?
Yes.
And let's see, Mr. Laneir, you were previously before this court on July 9th of 2020. And on that day, you pled guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The court assessed punishment that day pursuant to a plea agreement in which the court sentenced you to 10 years confinement in prison. And then the court suspended that sentence and placed you on community supervision for a period of 10 years. It was during that period of supervision that the state filed an amended motion to revoke your community supervision. And in that motion, they alleged 6 separate counts of violations. Have you had enough time to review those accusations with your attorney, Mr. Harden?
Yes.
Are you pleased with Mr. Harden as your attorney and the work that he's done?
Yes.
Do you understand everything that you've read and signed?
Yes.
Mr. Harden, do you believe Mr. Laneir to be competent to enter into a plea?
I do, Your Honor.
And does he intend to waive the formal reading of the state's motion to revoke? And is he pleading true to all counts?
He is, Your Honor.
Okay. And before we go any further, I see that the agreement today, as Mr. Harden's already announced, is upon Mr. Laneir's plea of true to the counts alleged. The state's recommending that his community supervision be revoked and that he be sentenced to 8 years confinement in the Texas Department of Criminal Justice Institutional Division, along with the balance of his financial obligations.
I think he has only got maybe $100 left, Judge. He has already paid everything. I got a sheet just a few minutes ago that's outlined that he has paid and has no court costs, no fine, and a reimbursement of $85 and a collection fee of $15, which would total $100.
Very well. Mr. Hartwell, I think there's an issue on the judgment. There's no place for the court to enter the credit time that Mr. Laneir would have.
152 days.
So can you have Ms. Abney just send over a new judgment?
Yes.
So, Mr. Harden, I'm going to have the DA's office present a new judgment because I'm not able to insert that 152 days credit into this digital judgment here. So, all right. So, Mr. Laneir, then we're going to go ahead and move forward with your plea. It appears that you would be entitled to 152 days credit towards your sentence for the time that you've spent in jail on this cause. Towards your 8-year confinement sentence today. So understanding those things, I'd ask you, Mr. Laneir, this time, how do you plead to counts 1 through 6 as alleged? Are those counts true or not true?
True.
And Mr. Laneir, you're pleading true to those counts because what is alleged in those counts is in fact true.
Yes.
And Mr. Laneir, has anyone threatened you, forced you, or pressured you to plead true to any of these counts today?
No.
All right, the court does accept Mr. Lanier's plea of true to each count as alleged. Mr. Harden, any objection to the court admitting the defendant's waiver of true? Is there any objection to the court admitting that into evidence?
No, Your Honor.
All right, the court admits the defendant's waiver of rights and plea of true to state's motion to revoke into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Your Honor, we
Kind of reset the phone. Check the phone was still haven't been able to give a free call. The internet's down.
Yeah, everything's going.
there it is.
Finally.
It just appears that the camera's off. Oh, actually, no, they're gone now. Mr. Hartwell, I don't know if it's easier for Ms. Abney to resubmit the whole thing or to do just the judgment. I'm not sure.
Your Honor, I think we could get just the judgment page, just that top page, pretty quick and easy. The doing the whole thing, I think would require, going through all the emails and signatures again, which if they're having internet difficulties out there, it might take some time.
Yeah. Right there. There you go. Now you can go small. There you go. Let's go. There. Richard's on. Go ahead.
All right, we ready to start?
Yes, Your Honor, we had a technological problem over this end.
No problem.
Power went out.
All right, so I believe the court had admitted the evidence. The court then took judicial notice of Mr. Laneir's plea of true to each count as alleged. Anything further from the state?
Your Honor, only that we did go ahead and resubmit the entire paperwork, so it will actually be in Mr. Harden's email as far as making sure that the jail time and the appeal waiver is all correct. I'll double check on that and make sure that
I need
it's
to
all.
sign it again.
I'm sorry.
I need to sign it again.
Yeah, yes, sir.
Okay, I can do that.
Well, no, you won't. You won't sign the judgment. Only the court signs it.
Oh, no, I'm talking about the plea papers. He said he changed something on it.
So go ahead and say again. I'm a little bit confused, Mr. Harwell. Go ahead and say again.
Yes, Your Honor. Miss Abney went ahead and resubmitted the entire plea packet with that correction. So I just forwarded that, so it should have the place for the court to enter the days, and I'll double check on that waiver of appeal as well.
Okay. All right, so Mr. Laneir, go ahead and have a seat because I've lost my ability to review the plea paper. So have a seat and I'll have to call you back up.
Yeah, Charlie.
State Ram, who else do we have ready?
And Mr. Adams.
All right, this is cause number CR 21-350, State versus Leon Thomas Baker. So for plea today, is that correct, Mr. Adams?
That is correct, Your Honor.
Let's see, let me see if I have plea papers. Have a seat, Mr. Baker. I don't have the plea papers yet, so I'll keep on monitoring that and see if I get them on time.
Right.
Are you ready on anyone?
Yes, sir.
Who would you like to call first?
Oscar Banda.
Cause number CR 25-63 versus Oscar Fabian Banda for pretrial.
One second. Judge, at this point, we don't have any contested pretrial motions. It's my understanding that the state was seeking additional documentation. I do know that I got in late yesterday and there's a lot of LGS notifications. They may have received it. If so, I haven't reviewed it. So at this point, no contested, but I would ask permission from the court for leave to file additional or late pretrial motions if that becomes necessary.
And Your Honor, state has no objection to that.
What's the status of our discovery that Mr. Schmidt's referring to from the state?
Your Honor, there is some hospital records. Subpoena has been sent out for those. The last time I checked, we didn't have them, but it has been a couple of days. So I'll recheck and check frequently, and as soon as we get them in, I'll share those with Mr. Schmidt.
So it's medical records?
Yes, sir.
Is it medical records of the deceased or someone else?
So, Your Honor, this is I know the docket says murder. This is actually indicted as an attempted murder. But yes, it would be the medical records of the victim.
Try to have the docket corrected again. All right, then the court will grant the defense permission to file late pretrial motions as needed. Court resets this then for docket call. Do you want August 12th, Mr. Schmidt?
That's fine, Judge.
Court sets Mr. Banda then for docket call August 12th, 1:30.
Christopher Bates.
This is cause number CR 25-118, State versus Christopher Robin Bates for arraignment.
That's correct, Judge. Mr. Bates understands the nature of the charges, range of punishment, his name spelled correctly. We waive reading, enter a plea of not guilty.
All right, the court enters Mr. Bates' plea of not guilty into the record. The court sets this matter for pretrial. Do you want that August 12th or August 26th, Mr. Schmidt?
August 26th, please.
Court sets Mr. Bates for pretrial August 26th at 1:30.
Go back to the agenda.
Judge, please. What? Roger Bridges.
Cause number CR 24-299, State versus Roger Neil Bridges. Docket call, go ahead.
Judge, we're gonna ask for an additional docket call. I got some things I need to discuss with Mr. Hartwell before we're ready to proceed.
No objection, Your Honor.
There being no objection, court sets Mr. Bridges for an additional docket call August 12th at 1:30.
Corwin Brown.
Cause number CR 25-66 and 67, State versus Corwin Lee Brown. Docket call, go ahead.
Judge, we ask to set Mr. Brown for a plea.
All right, court will set Mr. Brown for plea before the court August 12th at 1:30.
Judge, we need to reset Zachary Campbell. Apparently Ellis County was unable to get him on Zoom, so we won't have him, according to Ms. Tabor.
Court calls cause number CR 25-32, State versus Zachary Dale Campbell. We were set for docket call today. Court will reset Mr. Campbell for docket call August 12th at 1:30.
Jimmy Collier.
Jamie Dean Collier, CR 25-36. Mr. Collier is set for docket call.
Judge, getting close on Mr. Collier and asked for an additional docket call. So
Any objections from the state?
Your Honor, no objection.
All right, court will set Mr. Collier final docket call on August 12th, 1:30.
Matthew Hogg.
Matthew Tom Hogg, CR 25-43 for docket call.
Judge, we like asked to set Mr. Hogg for a plea on one of those August dates.
All right, court sets Mr. Hogg for plea August 12th, 1:30.
Mason Hogg.
Mason Edwin Hogue, CR 24-233 and 234 and FC 24-146. Believe we're set for docket call, all cases.
Yes, sir, that's correct in all cases. I would ask that we reset Mr. Hogue for docket calls in all cases. I think we've been here a few extra times on the CR 24 cases. The FC 24 is relatively new, so I'm not going to ask for a final docket call, but I know the court's getting ready to put that on us. But we would ask for an additional docket call.
Harwell.
No objection, Your Honor. Thank you.
All right, court sets Mr. Hope for docket call August 12th. 1:30.
Thank you.
Mark Thomas.
Mark Aaron Thomas, CR 25-17.
All right.
Except for docket call, go ahead.
Yeah, Judge, we have them for 17, 18, 123, 124. I received an offer from Mr. Harwell, I guess it was yesterday, in an email he sent, a comprehensive, that doesn't comport with what I believe we'd agreed to, and I need to talk to Mr. Harwell. Obviously, Judge, as you're aware, I was out for a while, so I haven't had an opportunity to pull that and review it, but I'm certain Mr. Harwell and I be on the same page. Those will ask for a final docket call on his case.
All right, court will set Mr. Thomas in all cases for final docket call August 12th at 1:30.
Judge, it's my understanding that Dustin Tinsley was set for an arraignment. It did not manage to get him over here, so we need to reset his arraignment date.
Remind me where he is.
Housed in Hopkins County.
Hopkins County. Housed.
All right, court resets CR 25-125, State versus Dustin Levi Tinsley for arraignment on August 12th.
I think the last one is Preston Wilson. I believe the state tenor motion to dismiss. I believe the court signed and granted that.
The court did grant the state's motion to dismiss. I signed it on June 30th.
Yes, sir.
Dismissing CR 23-83, State versus Preston Mitchell Wilson.
Got it. Okay, I think that's all I have to do.
All right, thank you, Mr. Schmidt.
Thank you.
And Mr. Adams, I do have Mr. Baker's plea papers now, if you want it.
Right.
All right, Mr. Baker, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Thank you, sir. You're lower again. Your name is Leon Thomas Baker, correct?
Yes, Leon Thomas Baker, Jr.
Did you say junior?
Yes, sir.
Okay. And Mr. Baker, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with Mr. Adams and the work he's done as your attorney?
Yes, sir.
Do you have any questions about the paperwork or the case before we proceed any further?
No, sir.
Mr. Adams, do you believe Mr. Baker to be competent to enter into this plea agreement, and that he's doing so intentionally, knowingly, and voluntarily?
Yes, Your Honor. He's legally, mentally competent. I'm not holding a gun to his dog's head to make him do this or anything like that.
Okay. Let's see, Mr. Baker, you are charged by indictment with a third-degree felony offense of fraudulent possession or use of a credit card or debit card in an amount of greater than 5, less than 10. That does carry a range of punishment of not less than 2 years in prison up to a maximum 10 years in prison, and a fine not to exceed $10,000. I see that there were originally some enhancement paragraphs that were alleged in the indictment. However, it appears that part of the plea agreement, those are being abandoned by the state, and the plea recommendation is, upon your plea of guilty, that the court would accept your plea of guilt and sentence you to 8 years confinement in prison, and then dismiss an unfiled unlawful use of a criminal instrument as part of the plea agreement in this case. In addition, you would be responsible for court costs of $290 and reimbursement fees of $160. Mr. Adams, what is the credit time that Mr. Baker is entitled to towards the time that he spent in jail on this cause?
Your Honor, between Mr. Baker actually being here in the Van Zandt County Jail and being in the Tarrant County Jail while Van Zandt County had a hold in place, those days total 458, according to the work done by Ms. Abney.
Very well. So, Mr. Baker, you would receive 458 days credit towards this sentence for the time that you've already spent in jail. Mr. Baker, is that your understanding of the plea agreement?
Yes, sir.
All right. Understanding those things, I would ask you at this time, how do you plead to fraudulent possession or use of a credit card or debit card in the amount of greater than 5 items less than 10?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Adams, any objection to the stipulation of evidence being admitted?
No objection is marked an offer.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance with victim services. Victim impact statement was sent out when the case was originally indicted, was never sent back. Neither did the state ever receive a request for any restitution.
Thank you, Mr. Harwell. Anything further from the defense, Mr. Adams?
No, Your Honor, we rest.
All right, then the court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court follows the plea agreement today. The court convicts Leon Thomas Baker Jr. of the 3rd-degree felony offense of possession, fraudulent possession or use of a credit card or debit card greater than 5, less than 10. Court assesses a sentence at 8 years confinement in the Texas Department of Criminal Justice. Orders him to pay a $290 court cost and $160 in reimbursement fees. Further, the court does dismiss under section 1245 of the Texas Penal Code, DA 2021-850, unlawful use of a criminal instrument. Court finds that the state has abandoned the enhancement paragraphs in the indictment. Court awards Mr. Baker 458 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Baker, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. I'm gonna have you step over to be fingerprinted.
Okay.
Anything further, Mr. Adams?
Nothing further, Your Honor. I think that's all I have on your docket today. My big excuse.
Yes, sir. Good to see you.
Good to see everybody. Not just the court.
Exactly.
All right, we're back on record in cause number CR 19-318, State versus James Laneir. Let me see where we were, Mr. Laneir. I think I was viewing the judgment to make sure that we had credit time. So credit time was 152, I believe, was the announcement. Is that correct?
Yes, Your Honor.
All right, and I believe, correct me if I'm wrong, Mr. Hartwell, Mr. Harden, did I pronounce sentence against Mr. Laneir pursuant to the plea agreement?
Not yet.
Okay, all right. The court, having considered the defendant's plea of true to each count, finds that it should accept the plea of true. The court having admitted the evidence, the court hereby follows the plea agreement. The court revokes the community supervision of James Laneir. The court sentences him pursuant to the plea agreement at 8 years confinement. The Texas Department of Criminal Justice Institutional Division court orders him to pay the balance of his financial obligations. Further, the court awards Mr. Laneir 152 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Laneir, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Good luck to you, sir.
Your Honor, may I be excused?
Yes, thank you, Mr. Hart. Sorry about the,
Not a problem, Judge. I don't
Technology.
have to do surgery for it.
appreciate you, sir. Have a good day.
Oh, Your Honor, my
Yes.
client has $100 on his books and there was $100, that 85 plus the 15 service fee. If the court takes it off his books, then we're all square.
Okay, I'm not sure that I could take it off. If the state and defense want to enter into an agreed order to do that, then I can sign that. Otherwise, I don't think the sheriff's office would be able to, we wouldn't be able to move money off of his books.
All right, well, I will, I'll see if the state will present me with an agreement and we will allow him to take the $100 out of the book so that my client is paid full.
I would appreciate that. And if I see that agreement and that order, I will get that signed.
Yes, sir. May I be excused now?
Yes, thank you, Mr. Hart.
Yes, sir. Okay.
Is that everyone on the jail docket, Ms. Abraham?
I believe so.
All right, then that being all of the cases, the court is going to adjourn. Thank you, Mr. Hartwell. Thank you, Mr. Hernandez. Thank you, Ms.
Thank you, sir.
Abraham. And thank you, Sergeant Martinez, if you're over there.
Thank you, sir, very much.
You're welcome.